In this video, I'll show you May 19th, 2023, the owner of the One Love. And YouTube channel, who we will refer to as Mr. Love, was pulled over by several officers with the Cumberland Police Department in Cumberland, Maryland, for allegedly failing to stop before turning out of a gas station parking lot. After his initial conversation with the officers, Mr. Love began to record the interaction, and we will begin our review of this encounter about 2 minutes after he began to film.
They called all these police for nothing. Tell me I pulled out the Sheets parking lot when there's oncoming traffic telling me I ain't make a complete stop. Why when I make a complete stop when there's oncoming traffic? That just sounds stupid. He pulled in the parking lot the whole time. Watching me.
We're gonna do a scan of the vehicle, so if you don't mind, just step out of the vehicle.
What for? What? Have I been suspected of committing a crime?
We can scan any vehicle we want as long as.
But have I suspected of committing a crime?
For a legal reason. So
that's a traffic stop. That's a traffic issue.
So do me a favor, step out of the vehicle.
Write me a ticket so I can go by my way. I'm not stepping out the vehicle, bro. I didn't do nothing. I didn't do absolutely nothing. If you pull me out this vehicle, I'm gonna file a lawsuit, bro. You violate my rights.
If you don't step out, I will.
I'm telling you. Well, you're gonna have to take me out. I'm not legally getting out my vehicle when I haven't done anything wrong. I was pulled over the other morning going to work for my headlight, right? I fixed it. I just came from my house, get gas, got me a soda, got my oil change. I seen you pull into the Sheets, eyeballing the car the whole time. I don't know why y'all keep pulling me over. I'm out here working because I'm in a union. That's why I got Mississippi tags. That's the whole reason.
The officers claimed that they stopped him for a traffic violation. Mr. Love argues that the officers did not have a valid reason to initiate a traffic stop and were pulling him over to investigate him due to his out-of-state license plate. As we've discussed before on ATA, the Supreme Court upheld the constitutionality of so-called pretextual traffic stops in the 1996 case of Wren versus the United States, where it determined that an officer's subjective motive does not invalidate an objectively reasonable stop based on probable cause that a driver had violated the traffic code, finding that the constitutional reasonableness of traffic stops does not depend on, now quoting, the actual motivations of the individual officers involved, and that, now quoting again, subjective intentions play no role in ordinary probable cause Fourth Amendment analysis. Therefore, even if the officer stopped Mr. Love because of his out-of-state plate, a court would almost certainly uphold the constitutionality of the traffic stop if it concludes that the officers also had probable cause to believe that he violated the traffic code. However, as Mr. Love claimed that he did stop before turning, it is important to note that if a court determined that the officers did not have the probable cause or reasonable suspicion necessary to conduct a lawful traffic stop, well then, any evidence that was discovered from the canine sniff would be inadmissible in court under the so-called fruit of the poisonous tree doctrine. In order for evidence to be admissible in court in a criminal prosecution, it typically must be obtained legally, although there are some exceptions. As the Supreme Court explained in the 2016 case of Utah versus Strafe, quote, in the 20th century, the exclusionary rule, the rule that often requires trial courts to exclude unlawfully seized evidence in a criminal trial, became the principal judicial remedy to deter Fourth Amendment violations. The fruit of the poisonous tree doctrine is an extension of the exclusionary rule, and as the Supreme Court also noted in the Strafe case, quote, the exclusionary rule encompasses both the primary evidence obtained as a direct result of an illegal seizure and evidence later discovered and found to be derivative of an illegality, the so-called fruit of the poisonous tree. Likewise, the Fourth Circuit Court of Appeals, which has jurisdiction over Maryland, stated in the 1992 case of United States versus Russia that, quote, if the initial traffic stop was illegal, the seized contraband is excluded under the fruit of the poisonous tree doctrine, applying this principle to Mr. Love's situation. If the initial traffic stop seizure was unconstitutional, then any evidence discovered during the traffic stop, including as a result of a dog sniff, would likely be inadmissible, even if the court determined that the dog sniff was properly conducted.
Pull me over in it. You pull my old lady over in it.
All right, well, if you
It's just ridiculous.
If you step out, we're going to scan the car.
What you gonna scan the car for? You can look and see there ain't nothing in the car.
Okay. Are you giving me consent to search the vehicle?
No, I'm not giving you nothing.
Okay, then step out of the vehicle.
No, I'm not.
Step out of the vehicle.
Call your supervisor, man. Call your supervisor.
Step out of the
I
vehicle.
want to speak to your supervisor, please. Call your supervisor. Call your supervisor. Call your supervisor. I'm telling you, pull me out the car. You up. You're making a big mistake.
For a legal reason.
You stopped me because you said I pulled up. No, you didn't come to the car and said, sir, you smell like alcohol, you smell like marijuana. None of that. Go to your car and then 10 police pull up like I'm supposed to be scared or something. I done been through this plenty in my life. I'm not stepping out of
this by now.
You're being recorded. We're being recorded, so.
You're more than welcome to record me.
I know I am. That's my right too.
Okay.
So let me roll down the window for him so he can see, he can smell, everything's clean. This is my work vehicle. You see my fishing poles? I like to fish. Yeah, look in there. Ain't nothing in here but work tools, fishing poles, a battery from my truck that I just sold, charge it up for this guy.
If you have nothing,
absolutely
nothing to worry
nothing
about, you can let them do their job here, and you can go about your business.
They can scan the car around. I'm not getting out though.
Once the dog alerts,
it ain't gonna alert. Well, that you just automatically saying the dog's gonna alert. That's what you're saying. You're on camera.
I said if.
No, you're pretty much telling me that.
I said if the dog alerts.
That's like you're pretty much saying.
What up?
You just telling me what you're gonna do. Whether or wait, it don't matter what y'all do, man. You just gonna violate the right. You can open the back door and let them in if you want.
Keep your hands in the car.
They searching to put the K9 around the car, y'all. For what reason? I don't know. Didn't say anything about nothing when he pulled me over, but all of a sudden he want me out of my vehicle to search
my car when I have done anything wrong. Speaking to the camera, Mr. Love states that the officers want to search his vehicle when he has done nothing wrong. In the 1983 case of United States versus Place, the Supreme Court held that the exposure of an individual's luggage, which was located in a public place to a canine sniff, quote, did not constitute a search within the meaning of the Fourth Amendment. In reaching this conclusion, the court reasoned that although, quote, the Fourth Amendment protects people from unreasonable government intrusions into their legitimate expectations of privacy. A dog sniff is now, quoting again, much less intrusive than a typical search because it does not require opening the luggage or exposing non-contraband items that otherwise would remain hidden from public view. The court also recognized that, quote, the sniff discloses only the presence or absence of narcotics, a contraband item, and that, now quoting again, this limited disclosure also ensures that the owner of the property is not subjected to the embarrassment and inconvenience entailed in less discriminate and more intrusive investigative methods. Building on this decision, the Supreme Court concluded in the 2000 case of City of Indianapolis versus Edmond that walking a narcotics detection dog around the exterior of a vehicle also did not constitute a Fourth Amendment search because, quote, just as in Place, an exterior sniff of an automobile does not require entry into the car and is not designed to disclose any information other than the presence or absence of narcotics. Likewise, in the 2005 case of Illinois versus Cobayas, the Supreme Court determined that, quote, the use of a well-trained narcotics detection dog, one that does not expose non-contraband items that otherwise would remain hidden from public view during a lawful traffic stop, generally does not implicate legitimate privacy interests, and that when a dog sniff is performed on the exterior of a vehicle during a lawful seizure for a traffic violation, quote, any intrusion on privacy expectations does not rise to the level of a constitution. Cognizable infringement. Therefore, the court concluded that, quote, a dog sniff conducted during a lawful traffic stop that reveals no information other than the location of a substance that no individual has any right to possess does not violate the Fourth Amendment. Viewers should note that a dog sniff during a traffic stop is not constitutional if the underlying seizure of the vehicle violates the Fourth Amendment, and we will discuss the constitutionality of the traffic stop in this interaction later in the episode. However, for now, It is important to understand that even though the purpose of drug detection dogs is to identify illegal substances, based on Supreme Court precedent, canine sniffs are not considered to be searches under the Fourth Amendment.
Work vehicle, I fish in it, I just got an oil change. Look, and he gonna tell me I pull out of the sheets without stopping when there's oncoming traffic. What sense does that make? Yes, sir.
I'm the canine guy.
Yep.
I just scanned the vehicle.
He alerted, didn't he?
No.
Yeah, because obviously now, because I mentioned he didn't. The way y'all treat people out here for absolutely nothing is ridiculous. And it has nothing to do with you personally.
Be careful.
He's been cool. You can finish what you was telling me.
So
Sorry
All good,
cut
brother.
you off, bro.
like I said, dog didn't alert to the vehicle, but I always interview anybody after I scan, whether the dog alerts or not.
Yeah.
Just because I want to make sure the dog's doing what he's supposed to. So there's never been any drugs in the car, nothing like that.
No.
All right. Works for me.
No drugs in the car.
Officer Baluk leads the canine around the vehicle while the other officers observe, and when the dog does not alert, he confirms with Mr. Love that there have never been any drugs in the car. As we discussed earlier in this episode, the Supreme Court determined in the Kobayas case that a dog sniff conducted during a lawful traffic stop does not violate the Fourth Amendment. However, the court clarified that, quote, a seizure that is justified solely by the interest in issuing a warning ticket to the driver can become unlawful if it is prolonged beyond the time reasonably required to complete that mission, and that the dog sniff in question was only legal because, quote, the duration of the stop in this case was entirely justified by the traffic offense and the ordinary inquiries incident to such a stop. Relying on the reasoning in the Kobayas case, the Supreme Court held in the 2015 case of Rodriguez v. United States that, quote, a police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures, and that absent independent, reasonable, articulable suspicion of additional criminal activity, a traffic stop justified only by a police-observed traffic violation cannot be extended in order to conduct a dog sniff. In the Rodriguez case, a dog sniff was conducted after the officer issued a written warning and otherwise completed the related inquiries of the traffic stop, extending the seizure by 7 or 8 minutes. However, the court clarified that the rule did not apply only to dog sniffs conducted after the issuance of a citation, and instead stated that, quote, the critical question is not whether the dog sniff occurs before or after the officer issues a ticket, but whether conducting the sniff prolongs, i.e., adds time to the stop in 2011. Perfectly legitimate utilization of a free investigative bonus to a valid traffic stop, so long as the traffic stop is still genuinely in progress when the dog alerts to the presence of narcotics. Likewise, in the 2018 case of Steck v. State, the same court reaffirmed that, quote, if the officer issuing the citation is diligently and legitimately still working on citations when the canine unit arrives, the traffic stop is still on, and the detention will be considered reasonable for Fourth Amendment purposes. The court also explored different cases when canine sniffs had been upheld, including a sniff that took place while the deputy who initiated the stop was still running the defendant's license and registration, and an alert that occurred before the officer had received the results of the registration and license check, and ultimately concluded that an 8-minute wait for a dog sniff was not an undue delay because one officer was still writing the citation while another officer conducted the canine scan of the vehicle. Now, in this situation, the same officer that eventually issued a written warning to Mr. Love was involved in the sniff process, and while he did not lead the canine around the vehicle, he stood and observed while Officer Baluch conducted the scan and did not appear to be working on Mr. Love's warning or other related processes during this time. Therefore, if a court determined that he abandoned the underlying traffic-related purposes of the stop to assist with the canine sniff, well, then it is likely that it would also conclude that the traffic stop was unlawfully extended. Of course, there may be additional facts at play that could sway a court's opinion, and in deciding the constitutionality of this dog sniff, a court would conduct a detailed review of the actions each officer took during the stop to determine whether the seizure of Mr. Love and his vehicle was unlawfully extended. Where do you work at? I work for Triton Construction. You see that? That one way they putting in downtown. I work for that company. So here's your warning here. That's another warning. I've done nothing. I don't feel like another warning, but here's your warning. Yup. Have a good day. Yup, I'm on my way to the precinct now. File me a lawsuit. After the dog failed to detect any drugs, the officers issued a written warning to Mr. Love and concluded the traffic stop after Mr. Love had filmed for about 13 minutes. It is unclear whether Mr. Love intends to file a complaint against the officers involved or pursue legal action, although he did suggest that he would file a lawsuit several times during the encounter. Overall, the Cumberland officers get AC for maintaining a generally condescending demeanor throughout the encounter and likely extending the traffic stop without reasonable suspicion. The officers also claim that they can scan any vehicle they want during a traffic stop without mentioning that they cannot extend the traffic stop to do so. And although this may have simply been an omission of speech, the fact that the officers likely unconstitutionally extended this traffic stop by not diligently working on Mr. Love's warning leads me to believe that it's more likely that they have a fundamental misunderstanding of the law. Additionally, I cannot say for certain whether Mr. Love stopped before exiting the gas station, but the officers certainly seem to be more concerned with finding drugs than enforcing the traffic code, as one officer even admitted during the stop that he did not write tickets. That being said, the Supreme Court has determined that police officers do not violate the Constitution by initiating pretextual traffic stops or conducting canine sniffs during lawful traffic stops. And while I certainly do not approve of these invasive investigative practices, they are technically legal. This encounter frustrates the ways that judicial decisions can often overlook the practicalities of everyday life, and I believe that the pretextual stop and dog sniff decisions that we discussed in this episode leave a significant amount of room for officer abuse when put into practice. Mr. Love gets a B- because although he voiced his concerns about the officer's conduct in a strong but respectful manner, he did not exit the vehicle when he was likely legally obligated to do so, and he seemingly consented to additional services of the vehicle. He also demonstrated some level of misunderstanding regarding when officers can conduct canine sniffs during traffic stops by arguing that they must suspect him of a crime before they can use a canine, when in fact they only need reasonable suspicion to extend the traffic stop, not to conduct the sniff in the first place. As we have discussed many times here on ATA, the Supreme Court has held that officers. Thank you very much for watching the video. Subscribe our channel for next video.